Hi everyone, the 2nd of May 2024. Now let's quickly proceed and have a look at the pointers of discussion for today. First of all is the editorial segment, and for discussion here, we have an Indian Express article which deals with the matter or issue of whether prisoners have a right to vote or do they have a right to contest elections while being behind bars. The title of this article is Why Can Accused Persons in Prison Contest Elections but Not Vote? This title itself is sufficient to answer the question. They do have a right to contest elections, but they cannot cast their vote. So why is this legal position? We'll have a look at all of these legalities in an elaborate manner. This is an important article. Secondly, we talk about the news updates for the day. And this is going to be followed by the last segment of legal news, where we have an update from the Supreme Court. So let's start with the article. Let's first have a look at the title of it. Why can accused persons in prison contest elections, but they do not have a right to vote? Let's see the context of it. See, last week, there is a person by the name of Amritpal Singh. Now, who is he? He is the leader or the head of a pro-Khalistan outfit, which is called Waris Punjab De. He is jailed currently, and he made an announcement. What was his announcement? He said that he intends to contest the Lok Sabha elections from Punjab's Khadur Sahib seat, which is to be held on 1st of June. Now, this person, he is behind bars, and he has made an announcement that he's going to contest the election. But at the same time, we have to understand that he cannot cast his vote in the ongoing Lok Sabha elections. So which means that prisoners, they have a right to contest elections, but they cannot cast their vote. And this is the position for prisoners across India. Now a question may arise, what is the legal status of right to vote or right to be elected or right to contest election? How does the law deal with voters and candidates who are imprisoned? Is the treatment different? And if so, why? What are the legal provisions concerned? Now, first and foremost thing that we have to understand is what is the nature of this right? Both of these rights, right to contest and right to cast vote. See, please note, very important thing is here that we need to understand. And this often features in your PT exam, especially in the miscellaneous portion or the initial portion of constitutional law, where questions may be asked as to which of the following is a feature of the basic principle doctrine or basic structure doctrine of the Constitution, or in which case, let's say, right to free and fair election was held to be if part and parcel of the basic feature of the Indian Constitution. So let's answer that question. The Supreme Court in the year of 1975, when we saw the emergency in our nation, which is often called one of the darkest periods of Indian democracy. So in 1975, the Supreme Court, in the case of Indira Gandhi versus Raj Narayan, recognized that free and fair elections, it is a part of the basic structure of Indian Constitution. Now wait, what is basic structure doctrine? Propounded in the case of Keshav Nanda Bharati and followed in the later judgments of the Supreme Court, the Supreme Court essentially said that under Article 368 of the Indian Constitution, sure, the Parliament does have the constituent power to amend or abrogate or limit any provision of the Indian Constitution, including those of the fundamental rights. Sure, Parliament can do that. But this power, amending power of the Parliament in exercise of their constituent powers under Article 368, it is not limitless. It has certain limits. It is circumscribed by the Constitution itself. And what is that limit? The limit is basic structure. In the case of Keshav Nanda Bharati, the Supreme Court categorically said that there are certain basic features, basic tenets, foundational features of the Indian Constitution, which cannot be amended by the Parliament, even in the exercise of its powers under Article 368. And one of the features is free and fair election. So free and fair election has been placed as the highest pedestal ever in the constitutional law. And what is the highest pedestal? Being a part of the basic structure of the constitution. But when it comes to right to vote and to be elected, are these also placed on the same pedestal? That is the question. So the answer here is they do not enjoy the same status as the concept of free and fair election does. So, for instance, a five-judge constitution bench in the year 2006, this is a constitution bench of the Supreme Court. In the case of Kuldeep Nair versus Union of India, you may also give note of the years of these landmark judgments. So, here in the case of Kuldeep Nair versus Union of India in 2006, the Supreme Court held that right to vote or the right to elect, as it was called then. So, the Supreme Court categorically held that right to vote, it is a pure and simple statutory right. This means that voting, it is not a fundamental right and it can be repealed by an ordinary law of the parliament. The same was held for the right to be elected by the bench, ruling that laws enacted by parliament could regulate both the right to vote and the right to be elected. And both of these are statutory rights. Please remember this term. Both of these are statutory rights. Now let's talk about the first limb of this article, which is accused persons having the right to contest elections. And once we're done with this category, then we talk about they do not have the right to vote and why. So for right to contest elections, we have a look at certain principles, certain provisions of the Representation of People's Act, People Act. Now, please note two bifurcations. Suppose there is a person, he is charged with committing a certain offense. When I say charged, what I mean by that? In our criminal justice system, let's talk about the stages of a criminal trial. What are the stages? And in this particular example, I'm talking strictly about a case which is instituted upon an FIR. So suppose there is an FIR which has been filed and now investigation is followed. Then the police files a charge sheet stating that the offense has been committed and there are grounds for believing that this offense is committed by such and such person. And here are the reasons, here are the documents justifying this conclusion of the police. So they file a charge sheet before the magistrate concerned. Then what does the magistrate do? Under section 190, the magistrate takes the cognizance. By taking cognizance, I mean that the magistrate is now applying his judicial mind to the matter before it. So the magistrate takes cognizance. Once the cognizance is taken, then the inquiry stage starts. Then following the inquiry, there are certain steps which are to be carried out, like issuing process, giving documents to the accused. Then the accused appears, telling the accused about the allegations and all of these things. Then comes the stage of charge framing. Now here the court frames charges. By charges, what I mean is that the court in category terms states to the accused that you are charged with so and so offense, you are charged with so and so offense. These are the allegations against him. So this is a formal writing of those allegations. All these provisions of the IPC are specified that you are charged under so and so a section of the IPC. And then the moment charges are framed, the trial starts. So we're talking about a person who has been charged. Now, this person who has been charged, he is disqualified. He can contest the elections. He is not disqualified from or barred from contesting election. This person can contest election. But suppose there is a person, the trial has been going on and now the trial has come to an end and the court has found this person guilty. And the person has been convicted. The moment the conviction is there, then he's disqualified. So what we saw is there is a person who is charged of an offense. He has a right to contest the election. But if there is a person who has been convicted, who has been found guilty, so then that person cannot contest election. He is disqualified. For this purpose, let's go to the Representation of People Act. There is a section, which is Section 8. If you've been following our TNA, we discussed Section 8 at length in the case of Rahul Gandhi's disqualification in the defamation matter in Gujarat. So Section 8 of the Representation of People Act of 1951, it is titled as Disqualification on Conviction for Certain Offences. This section has a list, an exhaustive list of certain sort of offences, and it talks about disqualification in those cases only. Suppose a person is convicted, he's been found guilty and convicted of any of the offenses in the exhaustive list which is provided in the provision of Section 8. Now, in that case, they will be disqualified from contesting the elections to the parliament or the state legislature from the date of the conviction onwards. So, suppose today he's convicted, from this date onwards, he's disqualified. Now, what is going to happen? He's convicted, he's going to be sentenced. Suppose this person is sentenced to 3 years of jail term. Now, what is going to happen? He's going to undergo this sentence term. And suppose this term comes to an end at this point. Now, from this point onwards, he's also going to be disqualified for another 6 years. So this is what is written here, that in that case, that is to say, in the case of his conviction, this person will be disqualified from contesting the elections to parliament or the state legislature from the date of conviction onwards, and he is going to face a further 6-year disqualification from contesting elections beginning from the date of their release following their completing the term of sentence. Now this qualification, this we've already discussed, that it kicks in once a person has been convicted, and this does not apply if a person has just been charged with the criminal offense. In recent years, this section has seen two major changes in the Supreme Court. Now let's see, there was a case in 2011 wherein the Public Interest Foundation, it filed a petition with the argument that persons who have criminal charges framed against them, or those who file criminal affidavits regarding their criminal history, those who file false affidavits about their criminal history, they should also be disqualified. Here we saw that person who has been convicted is disqualified and not a person who has been charged. This petition argued that why don't we disqualify those persons who file false affidavits with respect to their criminal history and those who have been charged with the criminal offense. However, a 5-judge constitution bench unanimously, in one voice, held that only the legislature could alter the Representation of People Act, and judiciary cannot direct the legislature to do or act in a certain manner with respect to an act. In 2016, advocate and former BJP spokesperson Ashwini Kumar Upadhyay, you must have heard his name in a couple of PILs during COVID time and also a couple of PILs in the MP MLA matter. So he filed a petition seeking a permanent disqualification for those who are convicted persons. So we saw that the disqualification is for the sentence term and then following that 6 years term. But here he has filed petitions saying that why don't we disqualify this person for lifelong. This case is still ongoing, and in November of last year, the Supreme Court, taking note of delays in criminal cases against MPs and MLAs, ordered the Chief Justices of all High Courts to register a suo motu case titled "In Redesignated Courts for MP MLAs for High Courts" to issue directions for the expeditious and effective disposal of these cases. However, according to a report which was submitted in April this year, this is the figure of the number of cases pending against MPs and MLAs. And what is the figure? It is 4,472. These sort of cases, they are still pending against lawmakers, against MPs and MLAs. Now, so far what we've seen is that once you're convicted, you're disqualified. Now, a question may arise in your mind, is there any leeway or is there any exception to this rule? So there are certain exceptions. One is that the Election Commission of India, it is empowered under Section 11 of the Representation of People Act to remove or to reduce the period of disqualification. In 2019, the Election Commission of India used this power to reduce the period of disqualification, which was faced by Sikkim Chief Minister Prem Singh Tamang. He was released following a 1-year prison sentence in 2018 for misappropriating funds for the procurement of cows. And as a result, the Sikkim Krantikari Morcha leader, he was Sikkim Krantikari Morcha leader, that is to say, this person, the CM, he went on to win in the by-elections for the Koklog Kamrang Assembly seat, the leader of this party. Now, another situation where a disqualified MP or MLA can still contest when their election is stayed on appeal to a higher court. Now, this is similar to what happened in the case of Rahul Gandhi. When the matter was before the Supreme Court, his conviction was stayed. So, see, please remember, this is the scenario. If, let's say, you've been convicted by the subordinate judiciary or the lower judiciary, then what is the recourse that you have? You file the appeal, correct? Now, in the appeal, suppose your conviction is stayed. There is a stay which is put on your conviction. Then what happens to your disqualification? See, your disqualification in any way, it is triggered by the conviction, correct? If you are convicted, let's say, for an offense which is punishable for more than 2 years, as per Section 8, then you're going to be, if you're convicted, you're going to be disqualified. Now, if your conviction itself is stayed, then what happens to your disqualification? So this is another exception. So this is that where the disqualified MP MLA file the appeal, and in the appeal the conviction is stayed. So then you can contest the election. In 2013, the Supreme Court held that once the conviction is stayed, then the disqualification which operates as a consequence of this conviction, it cannot take place or it cannot remain in effect, and the disqualification then is discarded and this person can then contest the election. Dhananjay Singh, a former BSP MP whom the district court convicted for kidnapping in 2020, he approached the Allahabad High Court for a stay on his 7-year sentence, which could allow him to contest elections in the Lok Sabha. So what has happened here? Dhananjay Singh, a BSP MP, he was convicted. What is the sentence term? 7 years. So under Section 8, what does it say? One of the situations is when you're convicted for more than 2 years, you are disqualified. Now here clearly is disqualified because the sentence is 7 years. So he approached the Allahabad High Court asking that kindly please stay my conviction so that my disqualification is taken away and I can contest the Lok Sabha elections. But the Allahabad High Court here refused to stay the conviction and granted him bail, while saying that it is high time, it is the need of the hour to have purity in politics. Now that we've done the first limb of the article, let's talk about right to vote. The bar against right to vote for confined persons, and the relevant section here is 62 of the Representation of People Act. What does this section do? It provides a series of restrictions on right to vote, including subsection 5. Subsection 5 here is important. Subsection 5 states in broad terms that no person shall vote in any election if he is confined in a prison, whether under a sentence of imprisonment or transportation or otherwise, or is in the lawful custody of the police. So whether you are undergoing a sentence and therefore you're behind the bars, whether you're an under trial prisoner, your trial is going on, whatever may be the reason, because you're imprisoned, so therefore you'll not be allowed to cast a vote. Now here I have a quick question. It is saying under a sentence of imprisonment or transportation. You must have read in IPC in your chapter which talks about punishments that this term transportation has been terminated from IPC. It has been omitted by virtue of amendment. Which is that amendment? Is it a government order or is it a full-fledged amendment? Please write down the answers in the comment section and also the year of amendment. That would be absolutely amazing. All right. So with an exception provided for these in preventive detention, this provision bars every individual who had criminal charges framed against them from casting their vote unless they have been released on bail or have been acquitted. So if you're released on bail or if you've been acquitted, then you can cast your vote. But if you're currently behind the bars when the voting is going on, then you cannot cast your vote. Now, a question may arise in your mind as to why this may seem to be unfair to you. So that is what the subject matter of this particular case was, and the Supreme Court gave certain reasons as to why this position. See, in 1997, the Supreme Court rejected a challenge to Section 62, Section 5, in the case of Anukul Chandra Pradhan, Advocate Supreme Court versus Union of India. So here the petitioners also argued that this is violative of their right to equality under Article 14. And why right to equality was invoked? They argued that if you're denying voting rights to under trials and those who are detained for being unable to furnish the bail amount while allowing those who are released on bail to vote, then that's a violation of their equality. Now consider this situation. There is a person A, he's been behind bars and he's detained and he's unable to furnish the bail amount. He does not have the economic resources. He is unable to furnish the bail amount which is asked of him, and therefore is not released on bail. There's another person, he's released on bail because he was able to furnish the bail amount. He had the economic, resources. So isn't it against equality? You are discriminating against two persons based on their economic strength. One is in a position to furnish the bail amount while another is not. So that was the argument of the petitioners here. But the Supreme Court rejected this argument on 4 grounds. Please keep note of these. You may cite them in your essay also, whether you're justifying it or you're against this topic. So first is the court reaffirmed that right to vote, it was a statutory right. It was created by a statute, the Representation of People's Act, and there are restrictions which are placed on this right under the Representation of People's Act. And Constitution also has a provision, I believe Article 324, which talks about right to vote. Secondly, the court held that there is a resource crunch as infrastructure would have to be provided, and police would have to be deployed. Now, suppose there is a person who's behind the bars, there is an under trial. If he were to cast vote, then the police has to accompany him. Police has to, make arrangements for this person to cast his vote. So that would need another infrastructural development. Thirdly, the court said that the person who is behind bars or in prison is because of the person's conduct, and he cannot claim equal freedom of movement, speech, and expression. Because of his conduct, he is behind the bars. So he cannot claim equal freedom of movement, speech, and expression. Lastly, the court said that restriction on prisoners' right to vote, they are reasonable as it is connected to keeping persons with with criminal background away from the political scenario. This decision has been relied upon by the Supreme Court and Delhi High Court in recent past to dismiss petitions seeking voting rights for prisoners. I really hope this article was helpful. We've dealt with everything that needs to be discussed in this article with respect to right to contest elections, with respect to right to vote, what are the legal provisions concerned, what are the exceptions, what are some of the case laws. And now we proceed to the next segment. You can comment down in the video comment section if you found this to be helpful. And let's talk about the national news now. Telecom industry seeks ban on illegal Wi-Fi 6E routers. The Cellular Operators Association of India, representing major telecom giants like Reliance Jio, Airtel, and Vodafone Idea, it has urged the government of India to ban the sale of Wi-Fi 6E routers that utilize the 6 gigahertz spectrum band for data transmission. Please note the Department of Telecommunication has not yet decided on utilization of this spectrum of band. Next up, RBI issues draft framework for electronic trading platforms. The Reserve Bank of India has proposed a revised regulatory framework for electronic trading platforms in the wake of increased integration of the onshore forex market with the offshore markets. Now, what is an electronic trading platform? An ETP, it refers to an electronic system other than a recognized stock exchange on which transactions in eligible infrastructures are contracted. By eligible infrastructures, we mean securities, market money instruments, foreign exchange instruments, derivatives, or other instruments of like nature. This is an important and interesting update. Meteorite impact formed lunar crater in Gujarat. So NASA satellite recently captured pictures of lunar crater. What is the crater? Let's understand that first. Suppose there is a meteorite, it hits the surface of the earth. Now, wherever the meteorite or the celestial object, it hits the earth's surface, then a deep depression is created there, right? So that is a crater. It is called lunar crater. So a meteorite hit a surface in Gujarat, it formed a crater. It is called Luna because of the village concerned. The name is derived from there. So the Luna crater, it is located in Kutch district of Gujarat, India. It was formed nearly 6,900 years ago by meteorite impact. It has been seen recently by NASA satellite image. It measures nearly 1.8 kilometers. It is this wide. It is 6 meters above the crater floor. Now, a question might arise, what is its significance? Sure, a meteorite hit the place some 6,900 years ago. So what is the importance now? Please note it is very, very important because it adds to the region's geological and historical significance that is given. But in terms of our understanding of Earth, of meteorite strikes on the Earth, how it impacted the civilizations, the ancient civilizations, that is very important. So it contributes to understanding Earth's impact history and meteorite strikes frequency. Proximity to ancient human settlements raises question about potential impact. Further research may reveal Earth's impact history. How many meteorites, what is the frequency, how many of them struck India, then meteorites' effects on ancient civilizations. We are going to get some clarity, some added valuable information because of the spotting of this crater. Kathmandu tops list for unhealthy air worldwide. This is another important update. Thin layers of polluted haze has shrouded the atmosphere of Kathmandu, dipping the air quality of Nepal's capital, making it the city with worst air quality index. According to IQAir, which is an organization that measures the real-time pollution of 101 cities across the world, these are the top 5 most polluted cities, and you would be shocked to realize that all of these are Asian countries, our neighborhood. Rank number 1 is Kathmandu, Nepal. Second, showing very sad state of affairs, is New Delhi, our capital. Third is Chiang Mai. This is in Thailand. Hanoi in Vietnam is at the 4th position. Bangkok in Thailand is at the 5th position. And 6th is Dhaka in Bangladesh. The Indian Space Situational Assessment Report for 2023 has come in. The Indian Space Situational Assessment Report for 2023, this is compiled by ISRO System for Safe and Sustainable State Operations, Space Operations Management, and released by ISRO Chairman S. Somnath. It has revealed that more space objects were placed in the orbit in 2023 when compared to the previous year, thereby indicating a growing trend in space object population. This is another important update. I'm sure all of us are aware of the December 13 last year security breach of the Indian Parliament. Now, following that, now the Lok Sabha Secretariat, he asked Delhi police to step back from handling the security of the Parliament premises and CISF to be replaced. So now this is materialized. This has happened. The CISF has taken over parliamentary security from Delhi police. CISF personnel replaced 150 personnel of the Delhi police, including 54 women personnel who were deployed for the security of Parliament complex following the security breach in last year, December. This move was initiated on the request of Lok Sabha Secretariat, who asked the security unit of Delhi police to withdraw and CISF to take place. Please note, this is very, very important update. Admiral Dinesh Kumar Tripathi, he takes charge as the 26th Navy Chief. Please remember his name and also the outgoing chief. So Admiral Dinesh K. Tripathi, he took charge as the 26th Chief of Naval Staff in India, succeeding Admiral R. Hari Kumar, who held the top position for the past 2 years and 5 months. Another very important update, International Labour Day. When is it observed? This is observed on 1st of May. What is the other name? It is also known as the International Workers' Day and the May Day. So May Day, International Workers' Day, International Labour Day, all three same celebration, same commemoration on the 1st of May. Very important. In India's first Labour Day, it was celebrated back in 1923 in Chennai. As far as the theme for this year's celebration and observation is concerned, it is, just a moment. This is ensuring workplace safety and health amidst climate change. NCERT to review books every year. The Union Education Ministry has directed NCERT to annually review and update school textbooks before printing so that a focus can be made on reducing content load, and also so that we can incorporate evolving topics so that these books are not kept stale for years to come. Another important pointer that you may note is the full form of NCERT. It is National Council of Educational Research and Training. This update we've already discussed. It's a repetition. Now we come to the international news segment for today. First is this update. It's a geopolitical update. So let's talk about its background. See, there is a grouping of 3 countries, US, UK, and Australia. What is this grouping called? It is AUKUS. What is the purpose of this grouping? It was formed by the 3 countries in 2021 itself, very recently. It is a part of efforts to push back against China's growing power in the Asia-Pacific region. So to counteract the overpowering or the influence that China is showing in the Asia-Pacific region, to curb that influence, these 3 countries came together in the year 2021 to form this grouping. Now, South Korea has confirmed talks on joining this grouping to form it a 4-country pact. So South Korea has held talks on joining a part of this defense deal between US, Britain, and Australia. This update we've already covered in one of our past TNAs. So China launches 3-member crew to its space station. China's Shenzhou 18 missile, it takes off from the launch center and it has 3 crew members on board. It launches these 3 crew members to join its space station. The name of the 3 crew members was specified in the earlier TNA slide. I would like to reiterate that. First is the crew is there's a new crew. It is made up of Commander Ye Guangfu. He's a 43, a veteran astronaut who took part in the Shenzhou 13 mission in 2021. Then we have fighter pilots Li Kong, he's 34, and Li Gongshu, he's 36. This has brought us to the last segment of legal updates, where we have an update from the Supreme Court. This is an important update. This is with respect to Section 138 of the NI Act. See, the Supreme Court has observed very categorically that suppose there is a person, there is a complainant, he's agreed by the fact that a check is dishonored which was issued by the accused. Now, this accused person is compensated to the complainant. So, does this mean that the court can now compel the complainant that you enter into a compromise, you compound the case? The answer here is no. So, the Supreme Court observed that the courts cannot compel the complainant in a check dishonor case to give consent for the compounding of the complainant merely solely on the ground that the accused has compensated the complainant. The court also observed that mere repayment of the amount, it cannot mean that the appellant is absolved from his criminal liability under Section 138 of the NI Act. The court observed, and I would like to quote that out, even though the complainant has been duly compensated by the accused, yet the complainant does not agree for the compounding of the offense. And the courts therefore cannot compel the complainant that you compound or you give consent for the compounding of the matter. It is also true that mere repayment of the amount cannot mean that the appellant is absolved from criminal liability. These two are distinct. Compensating the complainant, that's fine. But it does not necessarily mean 2 things. A, that the complainant is automatically given his consent for compounding. No, that is not the situation. B, that the accused is automatically absolved from his criminal liability under 138. No, that is also not the situation. And now here, this is to be noted. In an earlier decision of 2017, in the case of Messrs. Meters and Instruments Private Limited and another versus Kanchan Mehta, the Supreme Court had held, it was held back in 2017, that even in the absence of consent, court can close criminal proceedings against an accused in case of Section 138 if the accused has compensated the complainant. So earlier the position was that if the complainant has been compensated, then the court can assume consent and can close the case. But this observation, it was overturned. It was this discretion which was given to the court to close the proceedings and discharge the accused. It was held to be not good by a 5-judge bench in 2021, and that case law was in re-expeditious trial of cases under 138 of NI Act 1881. You may note down this for the purpose of your, let's say, exams like RJS, where a question on case law may come. So the name of this particular case is Raj Reddy Kalem versus the state of Haryana and another. So with this, we come to an end of our TNA. Thank you so much for being with us. And please don't forget to put your answers about transportation in IPC in the comment section, and also just your general feedback on how did you like the editorial. Was it sufficient on the topic? Or if there is any other topic that you would want us to talk about, please feel free to mention it. Thank you.